Hello again. Welcome to this special podcast concerning recent developments and issues in family property law. There are a number of different areas I want to cover. They are A. Financial agreements and a pending case before the High Court. B. Identification of property and issues about how to list a schedule of assets and liabilities. C. The use of light cases in the exercise of discretion and consistency in application of legal principle. D. The interrelationship between sections 79.2 and 79.4 and the order in which the sections are to be considered. And finally, E. Areas which are not particularly new but are not covered in the undergraduate course from which your earlier materials have been borrowed, which are interim part property settlement and interim costs funding. I haven't included any of the cases that I'm about to address in your compulsory reading, as there's plenty for you to do already. However, if you do have the opportunity to look at each of the cases that I address, you should. Let's begin with financial agreements. In September 2016, the full court delivered its decision in Kennedy and Thorne, 2016 FLC 93-737. In March 2017, the High Court of Australia granted special leave to appeal from this decision, Thorne and Kennedy 2017 HCA Transcript 54, 10 March 2017. At the time of recording, the appeal has either just been heard or is about to be heard, but the decision is not available. There are potentially far-reaching implications of the High Court's decision when it's made. A judge of the Federal Circuit Court had found that two financial agreements entered into by the parties, sadly the husband is now deceased, were not binding by reason of being entered into under duress. The husband, through his estate, appealed to the full court. The full court found the primary judge erred in determining the issue of duress. The full court found that the second agreement, entered into after marriage, was binding, allowing the appeal. The wife has appealed the decision to the High Court. The short version of the facts is that there was a 30-year age difference between the husband and the wife. He had assets of around $18 million, or to $24 million, depending on what you read, and 3 adult children from a previous marriage. The first agreement was signed before marriage. Both parties received independent legal advice. The soon-to-be wife was advised not to sign the agreement. This agreement was signed perhaps a couple of weeks before the marriage, which was in September 2007. In November 2007, the parties signed a second agreement, and seemingly identical or near identical to the first, although the full court doesn't seem to address the substance of the agreement in much detail. The wife at first instance sought to set aside both agreements on the basis of duress. However, she also sought that the agreements be set aside on the basis of undue influence and or unconscionability. The trial judge found there was duress, the full court found there was not duress, and in any event there was not undue influence or unconscionability. The evidence about the imbalance of power between the parties is summarised at paragraph 161 of the reasons for judgment of the full court as follows. A. From the moment the parties met, the husband expressed to the wife that he would provide for her and look after her for life if she came to Australia and married him. B. The husband made it clear that the wife would need to sign a document prior to marrying that acknowledged his wealth was his and it would go to his children. The wife was at all times financially and emotionally dependent on the husband, having permanently left and cut her ties with country B, and being in Australia on a limited visa. Just prior to the wedding, the husband arranged an appointment with the wife with a solicitor for the purpose of the wife obtaining legal advice about the financial agreement prepared by the husband's solicitor. Before seeing the solicitor, the husband told the wife that if she did not sign the agreement, the wedding would be off, and he told the wife and the solicitor that the agreement was non-negotiable. The wife's parents and sister had arrived in Australia for the wedding. The husband drove the wife and her sister to the appointment with the solicitor and waited outside. At the meeting with the solicitor, the wife became aware for the first time of the contents of the agreement and information about the husband's financial position. The solicitor provided her advice to the wife, and it was to the effect that the agreement was no good and she should not sign it. That verbal advice was followed up by a detailed written advice by the solicitor, and in a subsequent appointment the solicitor went through that written advice with the wife. Despite the legal advice, the wife signed the agreement and the wedding went ahead. As to the second agreement, the wife's position had not changed in that she was still entirely dependent upon the husband and similar conditions were in place. The wife saw the same solicitor and was given the same advice, but despite that proceeded to sign this agreement, this second agreement. There are a few things about this case that concern me. I went back to the first instance decision, Thorne and Kennedy, 2015 FCCA 484, 4 March 2015, from the Federal Circuit Court. My first concern was that the case may have been run too narrowly, just on the issue of duress. However, having read both the trial judgment and the full court appeal, it appears that all of the issues of undue influence and unconscionability were raised in the alternative. On the face of it, I don't think there is another vitiating factor that I could think of that would assist, save for perhaps an estoppel in favour of supporting the wife for her life and preventing enforcement of any agreement to the contrary. The other issue is that of spousal maintenance. The agreement provided, or the agreements provided, looking at page or paragraph 52 of the trial judge's reasons, that the wife would be paid $4,000 per month, plus a proportion of certain management rights. This is where I think a problem arises. Section 90F says this, that if a court is satisfied that when the agreement came into effect, note the wording, not when it was signed, when it came into effect, the circumstances of the party were such that, taking into account the terms and effect of the agreement, the party was unable to support himself or herself without an income-tested pension, allowance or benefit, then the provision is, in effect, void. The second agreement therefore came into effect at the date of separation or shortly thereafter, when the husband signed the separation declaration. I can't see any discussion in the trial judgment nor in the appeal about whether, as of 2011, the wife could have supported herself without an income-tested pension or benefit, taking into account the terms of the maintenance order. If she couldn't, then the provision was void. In that instance, perhaps a substitution of a lump sum spousal maintenance order, especially since the husband had died, would have been appropriate, backdated to the date when the husband was still alive. This, I think, should have been argued in the alternative. I infer from the absence of the cross appeal and from the lack of argument about that at the trial that the wife could support her reasonable needs based on the maintenance being provided. It also concerns me that there is no reference in the full court decisions for submissions that, in the event that the appeal was allowed, that the matter be remitted for hearing on the spousal maintenance issue. My other concern is about a potential variation of the spousal maintenance provision. If provisions for maintenance are in a financial agreement, they are enforceable as if they were an order of a court, pursuant to Section 90, capital A, subsection C. If that were the case, then treating the provision as if it were an order would be, in effect, a spousal maintenance order made in 2011. Given that the husband had subsequently died, the court could have considered a variation of that spousal maintenance order under Section 83, that's a change of circumstances since the previous order was made, and then, because of the inability of further periodic payments, the payment of a lump sum. So I am concerned the wife may have missed out on a potential claim here. However, I have not seen or know of a case that has been treated a spousal maintenance provision in a financial agreement this way. Perhaps I'm being a bit too creative about some of the sections. I'll leave that to you. The matter continues, and I look forward to hearing what the High Court has to say. I would expect a decision towards the end of 2017. The next issue I want to address is how to deal with assets and liabilities. In the textbook Family Law Principles, Judge Harland and I looked at alternate ways of expressing ownership of the parties. I was, at the time of writing the chapter of Family Law Principles, the updated chapter more correctly, of the firm view that trial judges should be dividing the value of joint property in accordance with legal title to ascertain the party's starting position. However, owing to some other research that I've been involved in, as yet unpublished, I think I need to concede that the overwhelming approaches of trial judges is to simply list jointly owned property as joint. To explain the competing approaches, I'm going to provide one example from the Federal Circuit Court of each approach. Neither is, of course, binding authority. The first approach is from Nash and Nash, 2015 FCCA 1359. The facts of the case are not material for us. What is on the slide and is also reproduced in the transcript is the schedule of assets and liabilities from that case. The schedule simply shows that proceeds of sale of a property are described as joint. If, for example, these parties previously owned the property's tenants in common in equal shares, then, as a starting point, don't they have equal interests in those funds? However, in Nash, as in many other cases, joint property appears to be simply described as much. In contrast, and I encourage you to read this decision, is that of Justice Austin in Welch and Avenue No. 2, 2015, FAM CA 1116, 14 December 2015. I've not included the schedule of assets and liabilities as it is too complex. However, these parties, aside from one real property, owned all of their property separately. What Justice Austen did in Welch is to assign, as part of the first step of identifying the property of the parties, a half interest in that jointly owned property to each of the parties. Because all the rest was owned separately, His Honour was then able to determine the starting point of each party's separate interests at law. He found that the wife's assets, including her half share in the real property, were $1.5 million or so, and the husband's interests, including his half share in the property, $1.259 million or so. I recommend you take a look at Justice Austen's approach. However, the approach from Nash and other cases like it is, both for the purposes of this course and it seems in real life, acceptable. However, as a necessary minimum for this course, the ownership of the property, whether husband, wife or joint, must be identified. Let's turn to the next issue of like cases in the exercise of discretion and consistency in the background of legal principle. The background begins with the 2013 decision of Petruski and Balua, 2013 49 FAM LR 116, where counsel for one of the parties relied on a number of similar fact first instance decisions in assessment of the appropriate range. The full court described this as an unhelpful exercise, saying, quote, "Whatever another judge may do in another case on the basis of the facts in that case can rarely, if ever, determine what is done in the case at hand." In 2014, in Damon and Damon, the full court cited Petruski and Balua with approval, adding, at paragraph 63, quote, "There is no necessary basis for the overall assessment of contributions, for example, in one case to be decided in the same way as in other cases, simply because there may be broad similarity between the facts of those cases." In Fields and Smith, counsel for one of the parties furnished the trial judge with a comparable table of so-described special contributions cases, which the trial judge incorporated into the reasons for judgment. Chief Justice Bright and Justice Ainsley Wallace wrote the table could only amount to the glibest of comparisons, which risked detracting from determining that the proposed orders were just and equitable. However, the full court, in the 2000 decision of Wallace and Manning, re-examined Petruski and Balua, Damon and Damon, Hoffman and Hoffman, and Fields and Smith, amongst others. Chief Justice Thackeray, Justices Ainsley, Wallace and Murphy wrote that, in effect, each of these earlier cases had failed to properly cite or consider the earlier full court decision of G&G, in which the full court wrote. And on the transcript, there is some points that are bolded. They are bolded by the court, not by me. It is the duty and function of this court to scrutinise the exercises by trial judges of the discretion vested by them in the legislation, and by a process of careful analysis and comparison of like cases, and the promulgation of guidelines for the exercise of the discretion, to attempt to ensure there is a reasonable measure of consistency of outcomes, and therefore predictability of result in similar cases for the ultimate benefit of the litigating public. As I said, the emphasis is from the full court, not me. Thackeray, Ainsley, Wallace and Murphy JJ added that, while no two cases are the same, comparable cases can, and perhaps should far more often, be used so as to inform, relevantly, the assessment of contributions within Section 79. This was subject to two qualifications. First, consistency is the aim. Second, quoting Chief Justice Gibbs from Mallet and Mallet, earlier decisions could do no more than provide a guide. In Wallace and Manning, the full court also examined the High Court decision of Barbaro and the Queen, which concerns sentencing discretion in criminal cases. Thackeray, Ainsley, Walls and Murphy, J.J., paragraph 69, wrote, "What the plurality said in Barbaro of the sentencing discretion is what can and should be said of assertions as to the, quote, range, unquote, in assessment of contributions or overall results in the exercise of the relevant discretions in Section 79. The implications of this decision are unknown, but are potentially far-reaching. Walls and Manning may be the genesis of an entirely new academic discussion and line of appeals." The relationship between Section 79.2 and Section 79.4 of the Act has been subject of recent full court review in the case of Chancellor McCoy. In that decision, 2016 FAM CAFC 256, the parties to a same-sex de facto relationship had been together for 27 years. However, the trial judge declined to make any order altering the property of the parties. The parties did not own any property jointly. The decision was ultimately upheld by the full court. Judge Leanne Turner, in her trial judgment in Chancellor and McCoy, relied upon a comment in the earlier full court decision of Chapman and Chapman that, quote, a judge is not obliged to take into account the matters in Section 79.4. Then a judge is at mere liberty to do so in determining whether it is just and equitable to make any order altering property interests. In Chancellor and McCoy, Turner J took into account, amongst other things, the absence of sharing of financial information, the parties not making provision for the other in the event of their death, and a lack of joint financial decision-making. The full court wrote that the trial judge, having determined that it was not just and equitable to make any order, did not need to make an assessment of what the appellant's entitlements might have been had she decided it was just and equitable to make some form of property order. Submissions suggested the trial judge had wrongly used Stanford as a reference point. In rejecting this submission, the full court wrote this: "These arguments reveal a misunderstanding of the ratio of Stanford. The point forcibly made by the High Court was that it is not appropriate for a trial judge to proceed to consider what is an appropriate property settlement without first determining whether it is just and equitable to make any order at all. This decision concerns me. The inference is that Section 79.2 of the Act is used to determine whether or not any order should be made. Then Section 79.4 is limited to determining only the quantum and perhaps the composition of any order. To me, this doesn't sit well with the opening words of Section 79.4 of the Act, which require a court to consider and take into account in determining what order, if any, is just and equitable. I suspect more appeals on this point will follow. This leads me to take you through some remedies available which are not particularly new, but not considered in the undergraduate course in much detail. The first is the power of the court to make an interim property settlement and interim distributions, and second for interim distributions for litigation expenses. Both of the issues are addressed in some detail by the full court in Strahan and Strahan, interim property orders, 2011, FLC 93466. There are a number of Strahan decisions, so don't get yourself confused. The facts of the case themselves don't have a lot of bearing on our discussion here. The full court's discussion summarises the relevant and to some extent overlapping principles. The first point is that a portion of a property pool can be released to a party on an interim basis. The power for this might be found in the power to make an interim costs order, or an interim property settlement order, or perhaps even in the spousal maintenance power. In relation to costs, the full court in Strachan noted, in Paletti and Pletty, Unreported Family Court of Australia 2 March 1990, Justice Nye, when describing an application for interim costs, referred to the reason of Wilson and Wilson, and said it is a situation where one party to the marriage controls almost exclusively might be described as the patrimony of the parties and has control of the bulk of the assets and funds of the parties, where an order may be made to ensure that the other party, who does not have the fortune of controlling those funds, at least has an equal or near equal opportunity to present his or her case. The full court in, and I'm going to pronounce it as Zschokke, S-Z-C-H-O-K-K-E, made a number of relevant remarks about the desirability of legal representation for both parties in family law proceedings. And I've placed that summary on the slide before you. In relation to interim property settlement, the full court in Strachan noted, if the source of the jurisdiction is Section 79 of the Act, in Zschokke at 83216, the full court said, if the order is to be made under Section 80, subsection 1, paragraph H, which is an order for property settlement until further order, it would seem that regard should be had to the requirement in Section 79 that the orders be just and equitable, and this would require the court to undertake at least some brief consideration of the matters in Section 79.4, including those referred to in Section 75.2. If, on a brief consideration of those matters, it seems likely to the court that the party who is the applicant for the interim order for advance of funds from the other party will be likely to be received by way of property settlement a sum sufficient to cover the advance, that would seem to be sufficient to enable the order sought to be made. And finally, one further comment from the full court. In Zschokke, the full court said, whether the matter was determined as an interim property settlement order under Section 81H, or as an interim costs or security for costs order under Section 1172, or indeed even a maintenance order, three matters would be relevant. Three matters would be relevant, namely 1, a position of relative financial strength on the part of the respondent, 2, a capacity on behalf of the respondent to meet his or her own litigation costs, and 3, an inability on the part of the applicant to meet his or her own litigation costs. Although I can't readily identify a specific reference in Strachan to the need for an identifiable fund from which amounts can be drawn, I think you will find the original statement in Hogan's case, which is referred to in Strachan, to that effect. Strachan is a reminder that there are really 4 different interim powers that can be utilised: an interim part property settlement, interim payment towards legal expenses, interim spousal maintenance, and, while not directly considered in Strachan, interim injunctions if necessary. These are important remedies to consider, especially if there is an imbalance of power in litigation. This completes my very brief run over some of the current issues, ends the podcast, and ends the module. Thanks for listening. Bye for now, and see you next time.